So the Supreme Court in Pennsylvania just issued a major Second Amendment victory. So let's talk about this. But real quick before we jump into this video, if you think that more courts should rule in favor of our Second Amendment rights, go ahead and hit that like button and subscribe. I also want to give a shout out to one of the main supporters of the channel, which is Blackout Coffee. Blackout Coffee has some of my favorite coffee out on the market, and they are my favorite Second Amendment supporting coffee out on the market. So if you guys are interested, I'll put a link down in the details section for you guys to go check them out. And if you use the code ARMSCHOLAR, you will get 10% off of your order. Also, I want to let you know that this content is powered by the Firearms Policy Coalition. So head on over to joinfpc.org to help support the Second Amendment cause. Thank you again, Firearms Policy Coalition, for supporting this channel. So the case we're going to be talking about in this video is firearms owners against crime versus the city of Harrisburg and their mayor. This is a case that has been around for many, many years. It's been working its way through the lower courts and found its way up to the Supreme Court of Pennsylvania. And we just got a favorable ruling from the Pennsylvania Supreme Court. And that has huge implications for future Second Amendment challenges in the state of Pennsylvania and maybe others as well. So let's take a look at what this case is. At issue in this case are various local ordinances that were passed by the city of Harrisburg. These ordinances included discharging guns outside of a gun range, possessing guns in parks, failing to report lost or stolen guns within 2 days, or having unaccompanied minors having firearms outside of their homes. And all these ordinances that were passed in the city have criminal penalties that were attached to them. Now, this case is based on challenging the local ordinances because they violate state preemption. Preemption is the use of state laws to nullify local actions. Essentially, a state can pass a law that says they occupy an entire area of law, including firearms law, and that any local laws that are passed which contradict those state laws become null and void. So, for example, in Pennsylvania, Section 6120 is their preemption law, and it states that no county, municipality, or township may in any manner regulate the lawful ownership, possession, transfer, or transportation of firearms, ammunition, or ammunition components when carried or transported for purposes not prohibited by the laws of this Commonwealth. So this case challenges those local ordinances in Harrisburg and claims that they are preempted by the state statute and their preemption statute, essentially saying that the local agency there had no authority to pass these laws whatsoever. Well, the issue is that when this case worked its way through the lower courts sought to have this case dismissed because they claimed the plaintiffs here in this case lacked standing. Now, standing is a legal term meaning that for a valid lawsuit to exist, the plaintiffs bringing the lawsuit must have sustained or will sustain an injury or harm that can be cured or fixed by the court. Essentially, the idea is only those people who are impacted by a law or an event can bring a lawsuit or challenge against that. Well, the lower courts here sought to have the case kicked because they claimed the individual plaintiffs would first have to wait until they have been charged with actually violating the ordinances before they could even bring the lawsuit. This amounted to the courts saying that the plaintiffs would first have to violate the claimed unconstitutional law, be charged with violating it, before they could ever even challenge the law whatsoever and bring a lawsuit against it. Well, here the Pennsylvania Supreme Court ruled that pre-enforcement challenges of this type are valid and that the plaintiffs do have standing and that their case should proceed forward. The court stated, the challenged ordinances put appellees in the position that this court has held is particularly well suited for pre-enforcement review in a declaratory judgment action. Similar to the municipalities in Robinson Township, appellees assert the city's ordinances impaired their constitutional rights to possess and use firearms and their statutory rights to be free from municipal firearms regulations. Further, like the physician in Robinson Township, which that's a case they're referencing, appellees here must choose whether to violate the challenged ordinances, surrender their constitutional and statutory rights, or avoid the city altogether. As the Robinson Township Court stated, our existing jurisprudence permits pre-enforcement review of statutory provisions in cases in which petitioners must choose between relinquishing their rights to comply with a law or willfully violate that law. The court goes on to state that the city offers no workable limiting principle, and we cannot discern any reason to limit standing in pre-enforcement declaratory judgments to those areas as long as the plaintiff demonstrates it is aggrieved in that its interest is substantial, direct, and immediate. The court here concludes by saying, for the foregoing reasons, we conclude appellees have individual and associational standing to seek declaratory relief for the discharge, parks, lost and stolen, and minors ordinances. This means that the court has ruled that the threat of enforcement and the dilemma of becoming a criminal or losing constitutional rights is enough to meet standing requirements to bring lawsuits like this. Now, this case isn't over. I want to make that really clear. This case will be remanded back down to the lower courts, where the courts will now have to address the real issue of this case, which is whether the local ordinances violate the state's preemption language. And that is the real issue of these cases, but they were kind of stalled out because the lower courts wouldn't even hear it because they said these plaintiffs lack standing. However, this is a good win in Pennsylvania and will help future cases in that state move along a lot faster because they won't be kicked for this standing issue. Also, you may see other states cite to Pennsylvania, although it's important for me to note that no state is bound by a different state's Supreme Court ruling, but sometimes you will see these cases pop up as persuasive arguments in other states, especially if these statutes and the language, preemption language or standing language or whatever is similar. You can sometimes see these cases be cited as persuasive. So overall, this is a good win. It's a strong win for Second Amendment rights. So more of these cases can be brought and won't get backlogged, won't get kicked when people are actually trying to challenge these Second Amendment violations that various states, local agencies, or whoever are trying to pass. So if you guys have any questions, go ahead and comment down below and I'll try to answer to the best of my ability. Also, if you like this video and like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and it signals to YouTube that you guys see value in these videos, in this type of two-way news, and then it helps push it to more people. So thank you so much to everybody who's liked, commented, subscribed, who's hit the notification bell. You guys are definitely helping support this channel, helping to support these videos, and helping these videos to reach more people. So if you don't have a comment in mind, just comment down below that you're coming to fuel the algorithm, and that really does help the channel. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this station was built by armed scholars and station will be maintained by armed scholars.